So I'm holding in my hand what is titled Bill Number 1890, Florida Senate 2012, with a date down at the bottom of 2/13/2012 at 9:49 a.m. Now, I regret that I had the delusion over the last couple of weeks that somehow by consumers and voters contacting their legislators, they might see reflected in the amendments to this awful legislation something which would reflect some concern on the part of legislators for the basic rights of Floridians and a respect that voters and citizens in this state are due by their elected representatives and senators. I am absolutely disgusted and disappointed to share with you the fact that the bill that I see reflects none of that. I was hoping that when this bill came out of Senate, there would be something in here which would reflect some concern for the rights and the interests of Floridians, but there is not. So what we have before us is a piece of legislation that is nothing but a gift to the banks and a slap in the face to every single Floridian. Now, there are so many provisions in here bad. I can highlight all of them as we go along, but I want to touch particularly on several sections that are absolutely repugnant and destructive to the basic notions of fair play, justice, and due process. I'll point particularly to Section 6 on page 13 of 41. This is Section 6. It amends Section 702.036 of Florida statutes. It's titled Finality of Mortgage Foreclosure Judgments. Now, here's why this section is so important. One of the only real threats or defenses that we as consumer defense attorneys and that you as property owners have is that if the banks and institutions engage in shoddy and improper practices, you might just have the right to get your property back if you go before a judge and you could prove that what they did is wrong even after a foreclosure judgment has been entered. But what this section does, where it's titled Finality of Mortgage Foreclosure Judgments, it says no matter what they do in a courtroom, if they're able to sneak and slide through a foreclosure judgment, your ability to get back that house is over forever. The limited exception if you didn't properly get served with proceedings. Thank you very much. We appreciate that. But that's not enough. The problem with this is this would condone and allow improper conduct and behavior to continue and give an incredible advantage to the banks and institutions no matter what their wrongful conduct is. Because of the language in here, this would allow the banks and institutions to remain in possession of your property, keeping title to it, letting that third-party purchaser stay in there, no matter what they did to improperly take that property. Now, they might throw a bone here and say, you can have a claim for money damages. What that says is, if you find that they've been lying, cheating, stealing, engaging in fraud, document forgery, whatever bad conduct, go ahead and file a lawsuit against whoever it was that sued or that took that back. The problem is, as we see with all of these shifting entities, we don't know who these plaintiffs are. We can't identify who these plaintiffs are. I've been screaming about this for years, that the failure of the foreclosure plaintiffs to properly identify who the corporation is and where they are located renders it next to impossible for us to effectuate appropriate counterclaims and defenses against those agents. Here's the bottom line. The plaintiffs in these cases are straw men. The plaintiffs in these cases are phantoms. The plaintiffs in these cases do not have real interest in these proceedings. The vast majority of them are simply servicers, and given their perilous financial situation for years, and especially now as situation has gotten worse, a claim that a homeowner may have for money damages against a plaintiff that improperly took a home is going to be absolutely worthless. And the fact that they were able to slip this in here is the clearest indication of what's wrong with this legislation. I will also note that I think this is the stealth horse within this entire piece of legislation. This particular piece of legislation is what the title industry wants, so that the title industry can avoid their responsibilities for all that's gone wrong in these foreclosure proceedings. The title industry, the banks know that the documents that clog our courtrooms are grossly improper, and yet what this legislation seeks to do is excuse all of that conduct. Not just excuse that conduct, but affirm that conduct. It takes us further and faster down a descent to lawlessness that this country cannot stand any longer. Make no mistake about it. What we all know to be the case is that the documents that have been produced in these foreclosure cases are improper. And the cure for that is not to excuse that conduct and reward that conduct. The cure for that is to dismiss the cases and force them to do them over again correctly. What this would do would excuse all that conduct, and that is absolutely inexcusable. The second provision in here, which is so grossly improper, is Section 8, 702.10. Order to show cause, entry of final judgment of foreclosure, and payment during foreclosure. Now, the initial section of this bill allows, in fact, mandates an in-camera review of the foreclosure case, and I quote, in chambers and without a hearing. Ladies and gentlemen, one of the fundamental concepts of our nation, this fine nation we used to be, was the right to confront accusers, the fact that we should have an open, fair, impartial justice system. This legislation, this provision in here, that's in paragraph 1, is repugnant to that, because it says that a judge shall take a foreclosure case that could be filled, that may be filled with lies and misrepresentations by the bank, and that judge, and I quote, shall review it in chambers and without a hearing. That is repugnant to the basic notions of justice, and yet it's in this piece of legislation. Turning now to page 18, paragraph 7. This is a Attorneys Relief Act. In these times where Floridians are struggling like never before, and frankly where the banks and institutions are hurting financially, this paragraph 7 is nothing but a windfall for the foreclosure mill and the plaintiff's attorneys that have gotten us into this mess from the beginning, and it's absolutely repugnant. Paragraph 7 provides that an attorney, a plaintiff's attorney, has a right to receive 3% of the principal amount of the mortgage without any hearing at all. Let me tell you why that's repugnant. If a plaintiff mill files a foreclosure on a $100,000 judgment and nobody files any response at all, 3% fee on that is frankly excessive. It's absurd. But here's where it just goes completely over the top. To say that that blanket provision, an attorney is entitled to 3% of the principal amount of the mortgage, is absolutely obscene when you know that that same attorney could file a $1 million mortgage and get a $30,000 fee, when the fact of the matter is there's no difference in the amount of work between a foreclosure judgment for a $100,000 mortgage than there is for one for $1 million. So to put in legislation that an attorney is entitled to 3% of the principal amount of the loan as an attorney's fee is absolutely obscene and repugnant. You, the consumer, would end up paying for that obscene and repugnant fee. And I would suggest to you that I think the judges in this state would find that obscene and repugnant. I've heard them in courtrooms say that I don't like paying these obscene fees when a plaintiff just gets a defendant to default and they think they're entitled to this money. No, we elect circuit court judges to make decisions, to exercise their discretion in determining what is an appropriate fee. Because again, keep in mind, the defendant in these cases ends up paying those. There's another section in here, paragraph 9 in this complaint, that's a big point. I don't want to speak too much about it because frankly they don't quite understand the damage that they're doing to themselves in here. But suffice it to say, when someone files an in rem action, talking out of both sides of your mouth and saying first that it's in rem and you can take the property back, and then at the same time you can go and pursue a deficiency judgment, is repugnant to the basic notions of justice, and it's a mess. But they're going to go ahead and do what they're going to do. Another huge element in here, and this has to do with the standard of proof that they are required to fulfill in these show cause proceedings. Bottom of page 20. If the court determines by preponderance of evidence, then they're entitled to a judgment. A preponderance of evidence is a pitifully low standard when we're talking about ripping away a homeowner's home. A preponderance of evidence is just a smidge over the top thinking that perhaps they've got it. In putting here in legislation that preponderance of evidence is all that it takes to get these show calls and throw a homeowner out of their home and give an attorney 3% of the principal amount of loan is absolutely repugnant, and yet that's what's in this legislation. And now we get to, if it's not the worst, all this is the worst. So you really can't pick it out one versus the other. Page 23. You know, ladies and gentlemen, rooted in our ancient law in this country are property rights. There's a book by Hernando de Soto called The Mystery of Capital, which describes that our basic property rights are the fundamental reason why this country became so successful. But the fact of the matter is that in our Constitution, our founding forefathers recognized that our right to retain property was preeminent. It was in fact a core of our Constitution and a core of our entire system of government. We recognized the primacy of property rights that made us different, special, unique, extraordinary. It's a foundation of our country. Paragraph 23 completely obliterates that. This paragraph 23 requires the homeowner, as a condition of having his day in court, to pay money to the banks and institutions regardless of the questionable nature of the pleadings that they have filed. It doesn't matter under this provision what legitimate defenses you may have. It doesn't matter what fraud, what document forgery, what improper conduct you could see right on the face of the complaint, because what this says is the court can determine and order the plaintiff or the defendant in a case to make payments as a condition of having your day in court. Again, in addition to the violation of basic property rights, it is a violation of basic due process that to think that in order to have your day in court to defend the home that you own, you would have to file and pay money to a bank or institution that all of us know many are engaged in grossly improper practices. It gets even worse on page 24. It states that if you fail to make this payment to the bank, this extortion, this blackmail, this payola to the banks and institutions that have done such destruction and harm to this country, they can order an immediate possession of the premises. Make that clear. If you don't pay these enterprises, I started to call them criminal enterprises, and perhaps I should be clear there. If you don't make these payments to them, they can demand an immediate possession of the property and throw you and all of your belongings out into the street. Again, this is a violation of basic due property rights. Section 10, it gets worse. Expedited foreclosure of abandoned real property. Ladies and gentlemen, there are many cases across the state. I've got ugly, ugly ones where the banks and institutions have taken it upon themselves to kick down the door, to invade property, to change locks, to throw property out into the street. This is a violation, again, of our basic property rights. Our rights against unreasonable searches and seizure, because effectively these banks and institutions are arms of the federal government, especially when they're acting under the color of court procedure. We see it again and again that if the banks show up and they want to kick down the door, they want to throw property out into the street, all they got to do is wave around a foreclosure complaint and say to the law enforcement officers there, they're in foreclosure and we're permitted to do this. But what this piece of legislation does in this section is codifies the practice of banks and institutions determining that your property is vacant and abandoned and allowing them to kick down the door, change the locks, and throw you out into the street. Now, we had suggested an amendment that if they want to do this, they should hire our local law enforcement to make that determination. And there's a prior bill by Senator Bennett which codified that and put in the hands of our local law enforcement some strict procedures to go through if the bank wants to make the assertion that the property is abandoned and therefore entitled to seizure. That has all been eliminated, and here we have process servers. Again, many of the folks that caused these problems in foreclosure cases from the beginning, the fact that these process servers could now be allowed to make the determination that your property is vacant or abandoned and thereby give cover to kick down the door, to change your locks, to throw your property out into the street is absolutely disgusting, and the fact that your legislators failed to institute those higher standards of having local law enforcement do it instead of these process servers is a desecration of our basic property rights. One other section here, that's section 11, having to do with mediation. Now, mediation has been destroyed in this state largely because of the unwillingness of the bankers to work with homeowners. But one of the things about this mediation section in here is it requires the homeowner to submit documents and information to the lender, but there's no reciprocity here. There's no requirement that the banks and institutions show any of their cards. I've suggested from the beginning that the banks and institutions, prior to entering the mediation with the homeowner, must be required to show life of loan history and some proof of authority to represent the owner of the loan in the mediation proceedings. The fact of the matter is, we're not going to have successful mediations until we know who the wizard behind the curtain is and who it is that's here negotiating on behalf. The whole thing is a piece of garbage, and the fact that our elected officials are not listening to the citizens of the state of Florida at all is another thing that should just get you out of your seats and doing something. And speaking of getting out of the seats and doing something, every single one of you who watches this video, every single one of you who cares at all about foreclosures, and frankly, every single one of you that cares about basic property rights in this state and the rule of law should be getting in your cars and driving to Tallahassee on Thursday so that you can meet with your legislators, your elected representatives, and tell them that you will not stand for this wanton desecration of basic due property rights and the destruction of the rule of law in the state of Florida on behalf of the banks. Let's keep in mind particularly what is happening here today. We've got the attorney generals that are selling out consumers all across this country with sweetheart deals that are allowing the banks to walk away for pennies on the dollar with almost no penalty at all that will be paid for not necessarily by the banks but also the investors, that's you, retirees, and other individuals, and really not suffering any consequence at all. That's excusing a broad range of criminal conduct and a range of activities that is repugnant to the basic notions of justice, fair play, and the rule of law. That just happened last week. Now we have this week, much closer to home, our elected officials not doing their job on behalf of the citizens of the state of Florida, but carrying the water and doing the job on behalf of the banks and the institutions, the frankly out-of-state institutions that have done so much wrong in this state and in this country. This is grossly improper. It only encourages and frankly hastens our descent down into madness and lawlessness, because this is lawlessness. It's got to stop. I encourage every single one of you, come to Tallahassee on Thursday, be part of the Mortgage Justice Group and the Rally and Tally. Spread this video, get on your Facebook, and get people up there on Thursday.